for joining Jennifer Strauss and Associates in our 2019 Webinar Wednesday series. We're coming to you live from downtown Washington, D.C. Our webinars are every Wednesday, and you can find the upcoming schedule on our website. Past webinars and all recordings are also on our website and on our YouTube channel, along with over 160 other recordings on federal contracting topics. All are complimentary. If you have questions for our speaker today, you can email her directly with contact information you'll see on the last slide. All right, this is a little bit about us. We are a Washington, D.C. based firm and provide services for federal contractors. This ranges from market analysis reports to proposal rating and also post-award compliance. More information is on our website, so please visit us there. We do offer advertising in our newsletter, so you can email this email if you'd like more information on that. All right, our speaker today is Devon Hewitt. She's going to be covering FAR compliance, what every sub needs to know. Thank you for joining us today, and I'm going to go ahead and hand it over to you.
Thank you. Good morning, and thank you for calling in to hear about this topic. In order to determine what every sub needs to know about FAR compliance, the contractor or the subcontractor needs to know what the FAR is and whether a particular provision of the FAR applies to the subcontractor, and then how to comply with that FAR provision and the risks of doing so. And that's the way I'm going to proceed here. Next slide. What is the FAR? The FAR stands for Federal Acquisition Regulation, and it is the regulation that applies, generally speaking, to procurements by executive agencies of the United States government. The actual applicability of the FAR provisions go to acquisitions, executive agencies, and appropriated funds. Those are the three talismans of what triggers FAR application. Now, the FAR applies to agencies and representatives of agencies. It doesn't directly apply to contractors. However, the FAR does require contracting officers and contracting personnel to include various clauses and provisions in government contracts, and particularly prime contracts, because the government doesn't have a direct relationship, which the specific term is called privity, with subcontractors. But the contracting personnel do have an obligation to include certain FAR clauses and provisions in prime contracts. And the difference between the term provisions and clauses is important. Provisions, solicitation provisions are provisions that are included in solicitations that apply to the procurement itself, and then generally delete or fall out of the solicitation once a contract has been awarded. And FAR clauses, the term clauses, applies to clauses that remain in the prime contract. So clauses affect performance, provisions, solicitation provisions affect the procurement, but they both types of provisions or both types of language comes from the FAR. Now, many of these FAR clauses, and by that I mean provisions that are included that remain in the contract and affect contract performance, also require the prime to quote-unquote flow down the FAR clause to its subcontractors. And that's known in the industry as mandatory flow down clauses. Other FAR clauses are discretionary by the government or contracting personnel. They are required to put in these quote-unquote mandatory clauses in the prime contract, but they also include other clauses that are not absolutely required by the FAR, but the FAR instructs them to do so in various contexts or types of procurements or a certain value of procurements. So a prime contract will include these mandatory FAR clauses as well as these other discretionary clauses that apply in different contexts. And to the extent there are these discretionary clauses in the prime contract, or a clause in the prime contractor does not mandate that the prime flow that down to the sub, the choice of whether the prime will flow down to its subcontractor is also discretionary of the prime, or subject to inclusion depending on the negotiations between the prime and the sub. So the most important thing here is to recognize that a subcontract is really a mixture of a government contract and a commercial contract. In one sense, it is just simply a contract between two businesses in a commercial transaction where standard commercial terms apply and a choice of law provision is included, making whatever state law applicable. But on the other hand, a federal subcontract also will have a number of references or clauses that stem from this regulation that applies to procurement, the federal government generally, then applies to a prime contractor, and then flows down to the sub. So becoming a subcontractor does not mean that you are only going to be faced with commercial provisions with which you might or have to comply. There are also this other rubric that would apply to the transaction and which may or may not be apparent when you enter into the subcontract. Next slide. So the first thing also, other than to figure out what the FAR is to determine whether or not you're a subcontractor. Because as I mentioned, in the prime contract, there will be clauses included by the government which, by their own language, state that the prime contractor has to flow it down to the subcontractor. And so it will say, pretty much in the last paragraph of that FAR clause, it will say to the prime contractor, include the substance or substantially similar substance of this clause in your subcontract. But for a prime or a potential sub, how do you know whether or not you actually fit that definition of a subcontractor and whether or not that needs to be flowed down in your particular transaction with the prime? And both the prime and the sub need to know this. Now, I will tell you that in an industry, the prime contractor typically flows everything down just to be safe. But from a subcontractor point of view, what subcontractors need to know is that not all of those clauses that a prime might flow down are actually required to be flowed down or are necessary in the context of the contract to be flowed down. So one of the most important things for a sub to realize is that, yes, there are certain clauses the prime must include in your subcontract, and the requirement does not extend to other prime contracts. But in order to be within the ambit of that required flow down, you have to determine whether you indeed are a quote-unquote subcontractor. And this is difficult under the FAR. There was a procurement reform panel that was authorized by Congress several years ago, and some parts of that are still ongoing. It's known as the Section 809 panel. And the 809 panel issued a report and said that the FAR and the DFARS, which is the Department of Defense FAR supplement, have 27 quote-unquote separate, sometimes overlapping definitions of subcontractor. And so sometimes companies are indeed subcontractors without realizing it. Now, if you have a contract with a prime contractor and it includes FAR clauses, there's a presumption that you indeed are a subcontractor as that term is used in a particular FAR clause. But that may not be true because of these various definitions. And the definitions may shift depending on the nature or the context of the clause. And for example, subcontractors or vendors or other companies that have contracts with a prime contractor may be considered subcontractors, for example, affirmative action, equal employment opportunity, veterans recruitment. A lot of the socioeconomic clauses flow down to a variety of organizations that may interact with a prime contractor, but that are not quote unquote specifically subcontractors as most people would define that term. The common approach and what most companies are used to is that any contractor that is providing either goods or services identified in the prime contract statement of work is a subcontractor. And so that type of relationship is pretty easy to recognize. If your company is doing some of the work that's being provided to the government, you are a subcontractor, and most likely the document you have with the prime will include some FAR clauses. Now, a question often arises with regard to a subcontractor. It knows that the FAR clauses that apply to it as an entity and to its employees, but are consultants 1099s, are they subcontractors to it? Are they what's known second-tier subcontractors? Or are they considered vendors and not otherwise subject to these flow-downs? Conventional wisdom says, again, that consultants who are assisting your company or a contracting company in performing part of the statement of work are also subcontractors and may be viewed as subcontractors to you with respect to a lot of these FAR clauses. But it may be that from the Department of Labor context, for example, that consultants are treated differently. So the biggest takeaway here is that it's not always clear on the margins whether or not certain FAR clauses may apply to a particular company. Again, contractors that provide part of the scope of work, that's fairly clear. And I think it's also clear that if contractors that provide goods and services that benefit the company as a whole, or even enable the company to perform the work, are probably not subcontractors. Another way to look at this is to look at what is a direct expense on the contract and what is an indirect expense. So, for example, your lease costs for your offices, or your technology costs, your security costs, whatever an office as a general procures for its operations is likely not going to be a subcontractor. But yet there are exceptions, and in particular, Department of Labor Affirmative Action Equal Employment Opportunity, the Department of Labor defines subcontractor differently. So that's an area for which contractors and subcontractors need to be particularly sensitive to. Next slide. Now, as I said, there are two types of FAR clauses that ultimately are in a prime contract. From the government's perspective, there are certain ones they have to include, and then there are other ones that they should include given the context of the procurement. The same standard applies to prime contractors. There are clauses in the prime contract that they must flow down to the subcontractors, and then there are clauses that they feel they must flow down, not because the term of that FAR clause requires it, but because in order to comply with that FAR clause in the prime contract, they have to get commitments or require their subcontractors to perform or meet the same standard. As I mentioned, the mandatory clauses are easy to spot. They actually have text in the clause instructing the prime contractor to flow down the substance of the clause to subcontractors. Now, the fact that it is a mandatory flow down clause does not actually mean that it is applicable to the subcontract work. In the best of all worlds, a prime would flow down those clauses it is required to flow down, but only in the context in which that flow down requirement appears. So, for example, FAR clauses in a prime contract may only apply to contracts above or below certain dollar thresholds, may only apply to certain types of contracts like fixed price cost reimbursement, may apply to only certain types of work or certain nature of the work. Is it a commercial item? So the fact that a prime says to a sub, well, this is a mandatory flow down, doesn't mean that, in fact, it is a mandatory flow down that is applicable to what you are doing. So again, subs have to be aware of the distinction between mandatory and discretionary, and then when it's mandatory, between whether or not that mandatory clause is in fact mandatory with respect to the work that subcontractor or entity is doing for the prime contractor. What subs also don't realize is that discretionary clauses can be negotiated. Now, of course, that depends on the subcontractor's leverage with the prime, but if a prime flows down the clause that it believes the subcontractor needs to comply with in order for it to comply with its obligations, then a prime is going to be reluctant to alter the text of that clause. But in other cases, the text really needs to be altered in order for the prime to actually comply with the clause in its prime contract. So, for example, Buy America Act, that is a standard FAR clause if you're providing certain kinds of, and I'll use the term widgets, to the government, and you can only use materials in that widget or that product you're giving to the government that actually have been manufactured in the United States. Now, there are a bunch of exceptions under something called the Trade Agreements Act, but in order to comply with that, you need to make sure your subcontractor is only buying America as well. But it may be that the Buy America provision only applies to certain types of materials or minerals from certain countries. And it may be that in the role you're playing, that doesn't apply, or it may apply to only part of it. So again, it may be appropriate to negotiate it, or it may be appropriate to say this really doesn't apply. More importantly, a lot of these clauses contain blanks or time frames that need to be altered. The common one is the substitution paragraph, because the FAR clauses are written with terms that reflect the contracting officer and the contractor, in that context, the prime contractor. But if it gets flowed down, it should reflect the relationship between the prime contractor and the subcontractor. But there are blanks for certain kinds of items or certain kinds of amounts. Most likely, the blanks have to do with timing. If you have to submit a claim within 30 days, do you want your subcontractor to give it to you on the 30th day? That may not give you enough time to turn it around. So you may want to ask the subcontractor to do it a little earlier, and the subcontractor needs to understand that as well. So the point here is that the FAR clauses are somewhat dynamic, even if they're mandatory, and they do bear a second look, which many subcontractors don't do. It is a resource allocation issue. They're complicated, and I'll talk later about how primes just flow everything down and put the burden on the subcontractor, but I do think it's something worth doing. Next slide. Most primes flow everything down, and you typically get an appendix with all the FAR clauses, and then there's a substitution paragraph. Sometimes, actually, FAR clauses will flow down that are not included in the prime contractor under something called the Christian doctrine. So there may be even obligations that you're not aware of, and you're held to them. And all I can say in that regard is, again, it's most likely the socioeconomic obligations that are otherwise imposed by statute, and maybe some of the other benefit society type of provisions, clean air, clean water, drug-free workplace, etc. Next slide. So here are the risks. When you flow down all these clauses to the sub now has the burden to decide what to do about these. As I've mentioned, some of those are mandatory, and there's really not much the subcontractor can do, except what it can do is say, all right, I'll accept all the mandatory flow downs if applicable. So that's a negotiation term they can include in the subcontract. They also can look at those FAR mandatory provisions and decide if there are any blanks or substitution issues that need to be closed in order to make sense. And then there are all the other clauses that are desirable or otherwise just flowed down because the government itself hasn't had the discipline to go through and actually identify those clauses that are applicable and necessary for the particular procurement. The prime is going to push that down. You can look at those clauses, and to the extent you think they're going to make a real impact, you could try to negotiate. Again, you could fill in the blanks, or you could again say as applicable. But there is one particular risk that both primes and subs I don't think have a full appreciation of, and that is order of precedence. You're going to have this appendix with all these FAR clauses, and then you're going to have the subcontract. And in the subcontract, you will probably negotiate on some issues or topics that are also reflected in the FAR flow-down clauses. Now, unless you are spending a good amount of time, using a fine-tooth comb to go through the entire subcontract, it is likely that there will be some conflict in the text of a FAR clause versus the text of the actual subcontract. And usually in the subcontract, there'll be an order of precedence. It says if there is a conflict, either the FAR provision will trump what's in the subcontract, or the subcontract provision will trump what's in the FAR clause. The problem is that may result in something that the parties did not intend. For example, disputes clause. The FAR disputes clause sets out a manner pursuant to which a prime contractor can submit a claim to the government in accordance with various procedures. Now, the prime contractor does not have to flow that down, but it may, just because it's part of its entire flow down package, and it could rely on that text for the purposes of the sub submitting a claim that it would transfer and otherwise turn around and submit to the government. But that text doesn't really address disputes between the sub and the prime. So the sub and the prime may include a disputes provision in the subcontract, which addresses subprime disputes or subprime disputes and prime government disputes and prime sponsorship of subcontractor claims. If that's the case, then which governs? The FAR disputes clause that's incorporated by reference, or the process for submitting claims to the government included in the prime contract? And also the disputes clause, the FAR disputes clause, may not say that you have to continue to perform, whereas the prime contractor will absolutely want the subcontractor to continue to perform while a dispute is pending. So those are issues that could arise in inconsistency. To make it worse, there is a FAR clause that in of itself has an order of precedence of clauses flowed down. So now you have two levels of order of precedence. The same issue is going to apply, for example, for data rights, IP provisions. The standard FAR IP provisions require the contractor to give the government certain licenses. Now that'll be flowed down most likely to a sub if they're providing intellectual property, but from the prime's perspective, they're going to want to take all the ownership of IP, and their standard commercial contract is going to include something like a work for hire provision where they take all IP rights in the IP that's produced by a subcontractor. However, the FAR clause only says that the sub has to give the government a license. Now, the prime contractor may use the substitution paragraph to substitute its position for the contracting officer's position, but as a matter of fact, the only end user is the government, and the prime may not have a need to have that. So an awareness of that allows a subcontractor to either modify the prime contractor to take into account the FAR clause or take into account a certain part of it, or to say that this IP clause in the contract takes precedence over the FAR clause. Again, many subs are not aware of the inconsistency and the impact or the consequences of an order of precedence clause if there is a conflict. Next slide. So ultimately, these are the best practices that I recommend for a sub. there are blanket statements often, not even with an appendix, where a prime will say a sub has to comply with all the requirements that the prime has to comply with. That's outrageous. Just reject that. If you have to accept it, say all applicable requirements. Typically, I say, turn over the prime contract. How do you expect me to comply with the prime contract if I don't have it? And many primes are not willing to do that. So say at a minimum, you'll comply with whatever is in your contract. And then if you get all those FAR clauses, and they don't allow you to actually negotiate them, what you can do, again, is say, okay, I'll accept the flow down, but only as applicable, because that will give you an ability to say, hey, this FAR clause is not applicable to me. You can modify that substitution paragraph to say, well, certain ones, the substitution for contracting officer for government will apply, but not in these cases, i.e. intellectual property. Or you may allow the government to audit, and the government does have the right to audit your expenses related to a contract, but you may not want the prime to audit. Or with respect to government property, if you are taking care of government property, your issues are really with the government, not with the prime. You can strike those clauses that are clearly inapplicable. The prime may say, well, if it's not applicable, it won't matter. At the end of the day, the right thing is to strike it, but you may have to pick other battles. And remember, you can negotiate clauses of discretionary FAR clauses, and you may need to do so because of blanks included in there or substitutions that don't work. But really, the most important thing out of all these best practices is to identify potentially inconsistent FAR versus subcontract provisions that are very important, whether it's payment, disputes, changes, intellectual property, termination. All those commercial standard terms could actually conflict with FAR terms, and that absolutely needs to be resolved in any subcontract negotiation. That's it. Thank you.
Thank you for joining us today. If you have any questions, you can reach out to us at email or phone number shown on your screen. And this concludes the webinar. Thank you.